Seismic versus Sterling Seismic Services. Mr. Irelan. Am I pronouncing it right? If not, correct me.
Irelan, like that.
Irelan, all right.
Good morning, and may it please the court. This case brings to the court an issue of first impression, and that is calculation of reasonable royalties under the Defend Trade Secrets Act. In the court below, the trial court concluded that the appropriate standard for reasonable royalties in this case and in all cases based on an often intoned standard that comes out of the university computing case is a party-centric test based on what a willing plaintiff, our plaintiff Silverthorne, and willing defendant Sterling would agree to as the price. When the court ruled in this way, it erred in two important and material ways. Number one, we agree with the Fourth Circuit in Airfax that this standard, this party-centric standard, does not comport with the DTSA because it embeds in it a requirement that the defendant put the trade secret to commercial use, and that element is no longer required under the DTSA. It was in common law, not under the DTSA. Now, bare disclosure alone is sufficient. So, and that's an important key because that's the claim that Silverthorne is making, is that Sterling simply disclosed its unlicensed data to Casillas, giving rise to a claim under the DTSA.
All right, you're off to a good start to explain to us the merits of the case, but you need to start with telling us how it is that we have jurisdiction under 1292B, because I don't really see that there is. I mean, that's a pretty limited statute, and I don't see that it's satisfied here.
Judge Smith, there's jurisdiction because, first of all, that the trial court has the discretion to, this court has discretion to accept jurisdiction over an issue like this. The issue of damages under the reasonable royalty calculation drives the entire case. It creates the pathway for whether Silverthorne presents evidence and whether it's relevant on, for example, other license agreements. If we don't have that standard established on what is the actual test that's going to be considered by the jury, the entire case falls apart.
Did Keith Ellison say that's what will happen? In other words, if we were to undo the discretion that our motions panel in consensus said, accepting this question, what would happen? So let's say you lose. We say the three circuit judges that decided to accept it were wrong. We're now going to unaccept it. What, according to Keith Ellison's statement at that hearing, what happens to the case?
I don't know that he has said directly anything on that.
But I thought you said he was wrong legally.
He is wrong legally.
Okay, so but he would presumably persist in his legal position. What would happen?
Well, what would happen is Silverthorne has no viable claim because if the standard is willing plaintiff in our case and willing defendant, it all devolves into a question of whether Sterling would agree to buy this seismic data.
They're a data processor, and they don't buy this stuff.
Exactly.
So the case is over.
The case is over because we can't present evidence.
On that theory, it's case dispositive. Second question is it legal or is it factual?
It's legal. It's a legal issue because it all comes down to what is the standard for reasonable royalties. Is it just this one standard that was seized upon by Judge Ellison, or is it a number of different potential approaches? For example, in university computing, the court talked about 6 different standards. And in fact, this standard was not used by the court in university computing. And alternatively, what they do.
Am I oversimplifying? I mean, you're saying there's a legal question. The 10th Circuit and the 4th Circuit have already said, we have a good answer. Judge Gorsuch, then Judge Gorsuch, Judge Kimkovich, and then the Fourth Circuit. Is that what you're saying?
That's what I'm saying. And
You want that same answer?
well, I think that the Airfax case sets out a perfect standard, because what it does.
Doesn't it set out the same standards that Storage Craft did, or is there some subtle distinction I missed?
Well, Storage Craft focused on the restatement, okay, and talked about, willing seller, willing buyer, just like we did, divorced from these parties, just to arrive at like a market rate for what the debt is. But interestingly enough, in Storage Craft, what did they rely on? They relied on the development cost for the software or the product, whatever it was, the code. Kind of like what was discussed in university computing as one option when you have two parties that are not in competition with each other, okay? And that was that Warren Petroleum case that was discussed in university computing. So what was the standard that was actually used in Storage Craft by Judge Gorsuch? Well, he at least affirmed, right, that the evidence was only the cost of development of the product, of the trade secret. But, he just brushed aside the objection that, hey, the defendant said, well, there was no evidence of that I used it. There was no evidence that Net Japan used it. He's like, that doesn't matter. We think that the evidence was sufficient to establish a reasonable royalty, which is what? So the standard in university computing is the actual value of the trade secret that was misappropriated. And that really needs to be the focus. That's what we're trying to do, right?
So the harm to you in this type of situation, a DTSA mere disclosure case, not under the common law where you look at profits and you get restitution on just, the harm to you is just the defeating of your confidential trade secret.
Absolutely, because that is the stock in trade for Silverthorne. That's what they sell. Silverthorne develops its seismic survey and then licenses off portions of it to different companies for substantial fees. 30, 25.
I guess my concern, though, is what's the limiting principle? I understand the logic of all that, but you can't say, for example, oh, well, Google would pay $5 billion for this, and then Sterling gets saddled with that? You're not. In other words, so how do we? If I agree with you that the UC case is how I think of it, built on common law, it's simply inconsistent with the DTSA in these mere disclosure cases. So we've got to answer and clarify that. If I'm with you on that, then what is the answer? Because I thought that the Fourth Circuit and the Tenth Circuit said most of UC is still correct. Those factors are still correct. So that's one question is, do those courts just revise UC, not reject it? And then two, how do we prevent a windfall in mere disclosure cases?
I have answers for both of those questions. One is with regard to, are we just rejecting university? No, we're not rejecting it, because I think it still, even 50 years later, provides us with a wealth of information about how to calculate reasonable royalties. But the factors, which is why I like the Airfax case and think it's appropriate, is, first of all, it's the focus there was finding what is a reasonable license fee. The factors all work. And in fact, we would be satisfied with this court embracing the Airfax approach by saying, find what a fair value is and use these factors that are set forth in university computing. Because listen to them and how they apply. In our case, one of them is the price paid for licenses previously. Well, that's exactly the evidence that we wanted to present at trial, was all of our contemporaneous license agreements that set the market for what this stuff is worth.
But you don't license with the data processors.
Say that again?
You're not licensing with the data processors.
That is correct, and that's the point, Judge.
So why would Sterling, what's the limiting principle again?
Well, the limiting principle is the market. What is a reasonable, what is fair? Remember, what we're trying to do is figure out what is the actual value, that's university computing, or the fair value, that's Airfax, for what was misappropriated. And what the value is what the market says it is. So, I mean, we're actually very unique in the sense that we have a lot of data points for what this seismic data is worth. okay? And so,
Worth to companies like Casillas, the oil and gas companies.
absolutely.
But
that's
not,
correct.
am I wrong? I mean, I don't mean to sound sarcastic, but they don't have any use from this in a mere disclosure case.
You're talking about,
They, Sterling.
that is correct. And that's the point, is they disclose to this third party. It's kind of like in the storage craft case. Think about it this way. Was the measure of reasonable royalties in storage craft based on what it was worth to Mr. Kirby? No, that was not the point. The point in storage craft was, well, what would it cost to develop for Net Japan, the party to whom it was disclosed? What would it cost them to develop our same?
That is sort of imposing strict liability on an inadvertent disclosure intermediary data processor, equivalent to the full value of this seismic data to the people that will go get the oil. And you just see I'm struggling with that.
Well,
But you say in mere disclosure cases, that's...
motive is not relevant. Motive is not part. It's not an element. It's not a part of the DTSA. It is simply the fact of disclosure. Now, can the jury take it into consideration? I think the problem is that if you look at the factors are all really focused on the plaintiff, aren't they, in the University Computing case? And in fact, that's what the University Computing Court said over and over again. You know, they warned against, penalizing a plaintiff by too realistic and sterile of a requirement of the defendant's agreement to the price for the data. But if Congress had wanted to distinguish between an inadvertent disclosure versus an advertent disclosure, it would have done so in the statute, and it did not. All of the factors here would weigh toward a presentment of the damage model for reasonable royalties exactly as Silverthorne suggests, which is changes in the party's competitive posture is irrelevant because we don't compete with Sterling. So the jury would weigh very low on that factor. Price paid by other licensees, again, that'd be very, very important. Value of secret to the plaintiff, including development costs. This is extremely expensive product for Silverthorne to create, $50,000-$60,000 dollars a square mile. So it's extremely expensive, which weighs and is important for the jury to understand when it is asked to award $485,000 for the value of these 15 square miles of data that were inadvertently or advertently. We don't know. That's left for the jury to decide. We believe it may have been intentional, but
Was the
again,
data returned? Has it been?
the data was, well, it doesn't work that way, Your Honor, but
It didn't. Probably a dumb question.
but
Keep going. Forget that question.
Casillas essentially has gone out of business. It sold off all of its assets, so it no longer uses the data because it's no longer in the business of using seismic to explore. So it was irrelevant whether they have it or not. It doesn't matter. But the answer to the court is yes, we did actually ask ultimately for it back, but it didn't matter.
So this appeal is all about damages, right?
It is, Your Honor.
Okay, but there would never be a question of damages without a finding of liability, is that right?
That is true.
All right, so how can the damages be a controlling question under 1292B at this stage of the litigation? We could spend weeks or months on the question of damages, but it might never come up. I just have a serious problem with whether we have appellate jurisdiction, because then it just opens up any kind of case to advisory opinions from a district court that may legitimately be uncertain about some issue. Well, why don't you just tell us about this issue so we'll know in advance?
Well, I guess I have two responses to that, Judge. First of all, the evidence is, well, first of all, one of the things that was said in University Computing was that the burden on the plaintiff is low. actually, because with regard to its damages, all it has to present is evidence of the value. But in terms of misappropriation in this case on disclosure, there is no fact question for the jury to even decide about whether there was disclosure to Casillas. There was. They have admitted it in the record in this case. So
there's no liability issue to be tried, is that?
there's not going to be a liability issue. Now, they will take issue with me on that because they are approaching this like a dog bite case where it's, the dog didn't bite me, and if it bit, it didn't hurt you, and if it hurts you, well, then you have no claim against us because it wasn't my dog. So they're using every single approach to defend this on all these technical issues. So, yeah, there will be issues that will, where they'll address whether we own our Seismic, for example. They'll go on those side issues. But the core issue of misappropriation, it is not in dispute in the case. Thank you.
You saved time for rebuttal. Thank you, Mr. Irelan.
Thank you.
Mr. Lloyd?
May it please the court, before I even start, Judge Higginson, your question was the data hurt. The answer to that is absolutely not. There's a contract in place that prohibits that data from being sent to anyone by Casillas anywhere.
And they're gone.
Well, there is a contract. They have a contract they can go enforce with that party. Stout contract. In the record, the Master License Agreement is what it's called, Master Geophysical License Agreement, but we've been calling it the MLA. In the record at page 724, look at sections 2.1. It also contains a provision that's interesting, 3.3.4. Our expert summarizes that in the record at page 228 also. It's an old expert report back then.
So your point there is what again?
That does not hurt. There's no risk that it's going anywhere, that it was never disclosed to anybody else. The record is very clear on that. The data was not
Never disclosed.
And use is not an issue, to be clear. Use is not an issue here. Disclosure alone is sufficient to trigger liability in the right situation. So we're not contesting that they have to show that we used the data. Nothing like that.
Keep going.
You're not following. Okay, you're.
No, I am following. I guess I'm wondering, you probably want this case over as much as they do. How long? But yet you are saying we should undo our discretion to decide this issue, or you're not?
You should not exercise jurisdiction here. Why? Why would you? You're right on point, Judge Smith. It's undisputed. A couple things that are undisputed. In their brief, page 20 of their reply, they quote you the existing measure. Right? They say that's what the law is right now. It is completely consistent with what Judge Ellison said the law is too. They agree that Judge Ellison correctly recited the law. That's undisputed. They're asking you to change it. You've got a jurisdictional issue. I think you've got a rule of orderliness issue potentially too. I didn't come here to argue that, but
but in your brief, as I understand it, and I'm looking at page 20. You do say you can only get compensation for use made by the defendant. And you just told me
the use made by the defendant matters because these parties, the question before the jury has to boil down to what would these parties agree
right,
to.
and that's what Judge Ellison said, and then that is he followed University Computing because it says, quote, the defendant must have actually put the trade secret to some use, commercial use. That's quoting from... No, that's in University Computing, which led to him, which led to your brief, and that's the legal issue that I heard you just say to me, you admit that isn't right legally. It doesn't require the use.
It's not required under the DTSA now. Mr. Irelan is correct. That was a common law requirement.
In University Computing.
Because it flowed from patent law.
Right, I agree.
Which has a different...
And it was stated in University Computing, and you say it, you convinced Judge Ellison that that's the law.
If you say anything, I guess you would say use is not required under the DTSA. Judge Gorsuch at the time has already said that.
So why wouldn't you want us to tell Judge Ellison stagecraft is the correct interpretation?
I totally agree. I do want you to say that. If you say anything, I think you ought to say in 2 sentences, we ain't looking at this, right? That's what I think. Because, we don't like all the rulings.
I agree. I appreciate that twin answer. But if we say nothing, he's just gotten up there and said what I think the hearing in front of Judge Ellison confirms, which is the case is over. without showing of harm as in use, they can't go forward.
I would like to address that.
Yeah.
Case doesn't have to be over. This is the path they chose, okay? A plaintiff in that situation can prove a case. They took the wrong approach, okay? They litigated this case as a lost profits, actual damages case for over 3 years. And then when it was whittled down to this was their only theory, they got serious about what's it going to take to prove reasonable royalty. And that's the only time that they thought, oh man, our evidence doesn't fit this. Let's go try to change the law. Let's go ask the Fifth Circuit to change the law. That's what they're asking to do here. If you look at their moderated measure and the existing measure, they are asking you to overrule a prior panel in university computing.
But you're saying it should be adjusted just as Judge Gorsuch did.
If you're going to write, yes, StorageCraft is the roadmap. A combination of StorageCraft and a case that we cited you to in a letter last week, RescueNet. RescueNet is a patent case where they evaluate the adequacy of the expert opinion testimony in that case, and they say testimony on non-comparable licenses is not sufficient.
Right.
Because
Am I right, though? Gorsuch warns about drawing from patent law, because there we have a world.
I understand, but there is logic to the expert qualification. I mean, not the qualification. Is there a reasonable basis for the opinion is what's addressed out in RescueNet, and it is very helpful, I believe. StorageCraft, you're right, though, is completely on point. The argument that we ought to revisit this case because it's 50 years old, okay, well, maybe, but StorageCraft is 10 years old, written by a now Supreme Court justice, analyzing, by the way, you will find this interesting. It's analyzing Utah law, the Uniform Trade Secret Act, the UTSA, like a lot of states have, right? When Congress passed the DTSA, you could look at it and go, that's substantively the same provision. Or you could go, it may not be exactly substantively the same because to our benefit, and I'm going to point you or your clerks to...
UTSA picked up on UTSA. Disclosure now is actionable. You don't deny that.
Correct. What they took out of the...
You're saying that's just what your client did, inadvertently, at most.
Totally accident, and there is no malicious intent. There's no evidence of any malicious intent. Nothing like that. Total accident. Their client told them to.
That sounds like you're conceding liability. It was an accident.
I'm not conceding liability. They have to prove that the rock under the ground, that a picture of the rock is a trade secret. I think they've got a tough hill to climb. We've got affirmative defenses that I think the jury can latch on. All this is, I hate to talk about I think in an appellate court, but that's why your point is right. We need a full record to percolate up in the normal course of things. I lost my train of thought. I want to tell you about StorageCraft, but I want to answer every question you got. Okay. In the UTSA, that if we're looking to legislative intent and parsing out the exact words and interpreting those words in the UTSA, it said, in lieu of damages measured by any other methods, the damages caused by misappropriation may be measured by imposition of liability for a reasonable royalty. That's going to be the first change is may be. They took out, DTSA, Congress took out the words may be, and they changed it to, and then the rest of it is, may be measured by imposition of liability for a reasonable royalty for a misappropriator's unauthorized disclosure. This is interesting to me. It's possessive still. Misappropriators is possessive, indicating, again, defendant's use, right? Our use. In all the cases, the defendant's circumstance is important, the defendant's use is important, because they always talk about a negotiation and a transaction. Justice Gorsuch specifically said...
It's important, but it's not dispositive.
It is.
Here you didn't use it.
It is the proper question for the jury to consider. What would these parties have agreed to every time? Because to have a negotiation, I have to care what I'm giving up and what I'm taking, what I'm receiving in return. And if you use Casillas, who has a completely different business, different set of priorities, completely different pocketbook, the whole circuit. I'm sorry, I'm doing a jury.
No, I agree.
It gets me fired up. It matters.
But
the jury has to be asked that question.
We just send it back down and don't answer the question. You still going to trial?
All right. When I was a first-year associate, the managing partner said pigs get fat, hogs get slaughtered. I'm content to go back on jurisdiction. I'm content for you to say it's affirmed, too, right? We will live with the evidentiary rulings, object again, right? I'm not waiving it now, by the way, but yeah, we don't think we should be here doing this. We want to get to trial. I want to get my client home to by Christmas, if we can, with Judge Ellison will give us priority when we get back, I believe, and get this thing over with. Okay, let me direct you back to the statutory interpretation issue I was going to bring up. They deleted when it says reasonable royalty for a misappropriator's unauthorized disclosure in the UTSA and in the Utah statute that Justice Gorsuch was looking at. They changed that to reasonable royalty for the misappropriator's unauthorized disclosure. So they're saying it in the statute too. It's possessive in the statute. This defendant, what they did with it, what does it matter? Intent may not be dispositive. I'm going to agree with Mr. Irelan there, but a jury's going to weigh that out. We also have a bad faith claim in response to this, where
I hear you saying that you're focusing, as you did in the brief, and as UC says, there'll be no damages if you didn't use it, and you clearly didn't use it.
I'm not. Well, use it. We did a job for our client and did great work, right? Didn't bill for it, didn't get paid anything for it, by the way. It's outside the scope. The billing was based on, the initial.
Third party pays the data processor, right?
Correct. That's our client. That's the demonstrative diagram I gave to the court showing the triangle relationship. The significance of that is also the record cites to those agreements and how we get to some of these numbers. But the other reason that so Gorsuch said it's beautiful to me to have his take on this, because he's looking at that statute, which we can say is either identical or better for us, right? And he's focusing on their use. Facts regarding motive and intent in that case were the opposite of this case. The hypothetical that Gorsuch gave in that opinion, he said Mr. Kirby is asking us to act as though he gave this to his tight-lipped grandpa who couldn't do anything with it, blah 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 blah, Yep. Where the facts were he did it to be a terrible person. He did it to be vindictive, right? He stole it knowing he could use it.
But aren't you worried about exactly my apprehension suggested to him? What's the limiting principle? If, in fact, it isn't tethered to use, there's no unjust enrichment, etc. Instead, it can be any hypothetical buyer-seller. Then you could be on the line for a great deal, because some people value this stuff a lot.
That's RescueNet. That's what the expert in RescueNet did. Inflated the damages. That's the words of the...
That's what you're most worried about.
That's what's happening here. You want to know why? They're not taking a net profits approach. My client, you can look at that demonstrative and get these numbers. If you look at it, the revenue per square mile for my client was $755 a square mile. Any chance in the world they would have paid $32,500 per square mile to gross $755? No. That's why they're taking this approach. A reasonable approach would be, and they don't have any evidence, they've not offered any opinion testimony on any of this, a reasonable approach in a case like this would be a net profits, right? You did work, you got paid for it, you used our stuff to do it, it benefited you, right? Well, what is a net profit analysis on $755 a square mile? When 15 square miles at most, we still disagree with that number, is used, all right? If they got 33% net profit on $755 per square mile, well, that's a huge profit margin, right? 33%. And then the licensing fee was 10% of profits. You know what that works out to? $25 a square mile. $375 would be right? That's what Google would pay Apple, or in your analysis of it, that's the way that would work.
What did university community mean about you can look at industry standards?
These parties, how they're situated, what's normal in this industry, right? I mean, that's why it matters. That's why it matters. The whole point is step back before the infringement. You're going to negotiate a deal for this. You infringed it, intentionally or not, right? Motive is irrelevant. You infringed, you used this trade secret, it benefited you. I believe the DTSA is set up to say you get actual damages like lost profits or unjust enrichment, and if those are difficult to prove, because this thing was passed because of espionage, because of foreign.
Finish your sentence. If those are difficult to prove, what?
If those are difficult to prove, then you get a reasonable royalty. Then we go to opinion testimony, right? If we don't have fact testimony on what the lost profits were or what the unjust enrichment was, that's the way I would analyze it. I understand it's not that case, and there are no lost profits here. That number's zero. It's not like it's hard to find, not like it's difficult to figure out how much the lost profits were. That number is actually zero. The unjust enrichment number is actually zero. So I question, but I'm not here to argue that. All right.
You're not even negotiating with Silverthorne, right? Your client is Casillas.
Correct. No, yes.
So there is no buyer-seller relationship between you and Silverthorne.
No.
But
They did benefit. They had a side, this is in the record too. They had a,
But isn't University Computing, when it's focused on use, it doesn't make sense. That's what, right?
well, that's okay with me because the DTSA is not there anymore. I don't think that part is not the law anymore. Is that, am I conceding too much?
I think Ellison seemed to think it was.
I believe, I don't recall the exact part he was talking about, and I believe he was talking about that's a factor that the jury should consider is what they did with it. And I agree with that. The jury should be instructed to consider things that matter, right? I want to go through, okay, so the DTSA changed that from A misappropriators to the misappropriators. They also could have stopped after reasonable royalty and didn't have to say liability for reasonable for the legislative intent is, I mean, not the legislative intent, the congressional intent is clear to me just in the statute, but look, you've already looked at it thoroughly. Justice Gorsuch goes
Now we're
through.
deep into the DTSA merits question. Could you go back to Judge Smith's questions in terms of, are you stating that under 1292, a court can never take a damages question because liability hasn't been determined?
Man, you put me on the spot if you ask me if this court can never. I can envision situations.
Isn't that what the Supreme Court did in Yamaha? 1292 review, damages before liability.
When the facts, okay, here we've got significant contested issues on liability, significant. Whether there's a trade secret at all, whether it was wrongfully misappropriated.
I'm just asking on the jurisdictional question, is it your argument, are you urging, I'm not saying you are, that we can never take a 1292 certified issue if liability hasn't been determined? Is that no, you're not taking that position.
I can envision scenarios where there could be a partial summary judgment on an issue. You know, I mean, there's all kinds of.
And that's Yamaha.
Right, and the facts are not developed here, and there's liability issues. We got affirmative defenses. Jury hadn't decided that, so they're asking you to overrule another panel. They're on an interlocutory appeal where it is undisputed. We have liability issues to decide, to the jury to decide. We have affirmative defenses to decide. They may never answer a damages question anyway, and all this is for naught, right?
So what's your best circuit case anywhere in the country that we would uncertify a question we've accepted because it's damages and that's not a legally dispositive? Do you have any case that stands for that proposition?
Uncertified, I mean.
Decide that it was not properly certified.
There are, I'm okay, you make me question myself right now, but I believe there are a lot where they say it was improvidently granted, you know, and that's no.
Because it's damages before liability?
Oh, okay, you're whittling me down. I can't cite you to an exact case right now.
But you're not concerned about the merits issue because you're thinking Gorsuch got it right in Storagecraft, has updated University Computing in the context of disclosure.
Sure, he updated it in pre-DTSA, and then according to, you know, but same statute, we know, right? You know,
So I mean, on the jurisdictional issue, I assume both sides would agree here that insofar as there's a question certified from the district court, it's entirely discretionary on the part of the Court of Appeals as to whether to accept the appeal under 1292B. So it's not something where we have mandatory jurisdiction. We have to take it as we would on a 1291. So, and there's also plenty of case law, published opinions from this court that say that the merits panel is perfectly free to override the motions panel.
Yeah.
So all we would have to decide is that we decline to exercise our discretion to grant the appeal, whether or not there's an absolute bar in terms of damages and liability.
I mean, to me, there's no dispute Judge Ellison got the law right. Page 20 of their reply says that. Why would we tweak it at this stage, especially?
Because this can also be used, I'm not suggesting it's happening here, but if we open the door to these kind of appeals, it can be used as a device to force settlement, because you ultimately find out, oh, these damages either would be huge or they'd be minuscule or non-existent, and then that forces the parties to settle at the trial level, which is not the intent of 1292B.
That's right. And to that point, procedurally, this case got a little off track, but if this was the first claim to go, they lost their negligence claim on 12B, they lost their breach of contract on summary judgment, they lost their actual damages case in discovery and admitted it the first day of trial after we had a jury impaneled, by the way. That's the first time we found out they didn't claim actual damages, right? If we would have moved for summary judgment on the reasonable royalty issue at the start of the case, when we knew, if we would have known back then would we have an interlocutory appeal asking you to reinvent the law, reimagine what university computing said? I only got 5 seconds, and I appreciate the opportunity to be here, unless y'all have any other
You're
questions.
submitting this chart.
I'm sorry, yes, I submitted that as that piece of paper is not in the record, but it's a summary, a chart of the relationship and where those documents are found in the record.
All right, thank you. Mr. Irelan for rebuttal.
Thank you, Your Honor. One of the cases that was cited on this issue of jurisdiction was the Fujitsu opinion, and in the dissent, there's a very robust analysis of why, under the facts of the Fujitsu case, that exercising the discretion to consider damages at this stage in the case made perfect sense, was reasonable, and I think all of the reasoning in Fujitsu in the dissent is echoed here today, because we have an issue that is undecided in the Fifth Circuit, and this gives guidance not only to this district court in this case, but also all district courts in the Fifth Circuit.
But opposing counsel says that on your reply brief you said Ellison got it right.
He is incorrect in the way that he phrased it. The only thing that we have acknowledged is that Judge Ellison accurately stated one of the standards that was embedded in university computing, but we didn't concede that it was correct. That's the whole point here, that we challenged it. It doesn't make any sense. It doesn't comport with the guidelines that this court set forth in university computing for how to establish reasonable royalties. The flexibilities that you have even talked about in Logics. The court has to use flexibility to come up with a standard, and it's just like they said in Airfax, this is not a one-size-fits-all situation. The court has to, I think this court has to direct the trial courts to use that flexibility to comport with the commercial setting of each case, and that's exactly the problem in our instance. The standard that was set out in university computing that Judge Ellison seized on was explicitly stated in the opinion to relate to competitors, direct competitors. And if you look at the opinion, there's a lengthy discussion about...
Did I quote it right, that the defendant must have actually put the trade secret to some use?
Yes.
And is that what he thinks requires proof of actual use?
Yes, Your Honor, I do. Because it's embedded in the standard. You have to be able to show what the license of the defendant would put the trade secret to the use. And use is an interesting issue because that was discussed in this Oakwood Labs versus Thanos case out of the Third Circuit. They went on to, the analysis was on the DTSA, and it was focused on what does use mean in the DTSA, and the court ultimately concluded that you just use the generally accepted definition of use, which they said was to employ to accomplish a purpose, or to accomplish the purpose. Here, the use that Sterling put the data to was to process it. And they did that for free, and They had, from us, in other words, we didn't pay them to process it. There was no relationship from us of a business. They did have a non-disclosure agreement in place so that they would keep the data private, because they received not only the licensed data but also the unlicensed data, so that they could process the entire seismic survey and then cut out only the portion that they then delivered to Casillas. The problem here is they disclosed the unlicensed data that they shouldn't have disclosed. So to the point of, in this definition where it talks about what use the defendant would put the trade secret, it doesn't make any sense in the context of our case. The court instead should have used a more flexible approach, and one flexible approach would have been the Airfax approach, where you're just looking at these various factors to come up with what is a fair value for what was misappropriated.
All right, thank you, Mr. Irelan.
Thank you very much.
Your case is under submission. Last case for today.